Awesome. Okay, welcome back, everybody. We have our next presenter. This is Erin Lacey, and the chair of Thompson Coburn's higher education practice. Erin has 2 decades of experience in assisting institutions to navigate complex legal and policy matters. He and his colleagues are valued for their deep understanding of the post-secondary regulatory framework, including requirements relating to the federal financial aid programs, accreditation, and state authorization. The host of Thompson Coburn's popular higher education webinar series and editorial director of Reducation, the firm's higher education law and policy blog, Erin is a frequent writer and speaker on topics relating to higher education policy and regulation. He currently resides in St. Louis with his wife, kids, the world's greatest dog, and 8 rowdy chickens, which I definitely need to hear more about those. They're chickens. Everybody, let's welcome Erin Lacey to our show. Take it away, Erin.
Thank you so much. Yes, that's true. We got the chickens last year. That is my wife's doing, and they're great. And now we have like 8 eggs a day, which is more eggs than I can eat. So we are constantly trying to give all those away. It's a pleasure to be here. I really appreciate you all offering us the opportunity to speak with you. And I thought what I would do this morning is spend a little bit of time chatting first about, we talked about all this. This is just about our firm. And I am in St. Louis, by the way. We have offices all over, but Thompson Coburn is based in St. Louis, and I live right here in Webster Grove. So pretty close, I suspect, to a number of you. I wanted to talk first about the department's new agenda and just give you a little bit of context. There is a lot of regulatory activity happening. I don't want to go too far afield. Obviously, our focus today is going to be on the professional licensure requirements and state authorization and the things that you're particularly interested in. But it's good to understand what's happening at the federal level, both to the extent that that involves the issues that you're responsible for, and also to the extent that those issues are not being put at the top of the department's list. That's good for you to know as well in some respects. And then we'll sort of downshift into state authorization. I'll talk about what I'm characterizing as the newish disclosures for professional licensure programs. I'm not sure we can really still call them new, but we'll talk through those. I suspect many of you have some familiarity with them, or maybe a lot of familiarity, but it's good to go back through and just make sure that some of the nuances are being considered. And then if I have time, I think we've got an hour blocked out. I certainly want to leave time for questions at the end, but if I can squeeze it in, what some folks have not been so keyed into, and I say folks, I really mean institutions of higher education, are some of the other disclosures that were required, some of the revisions to required disclosures that were made at the same time that the department promulgated the new state authorization rule. So I thought I'd hit on a little bit of that, and if that's not exactly in your bailiwick back at your institution, you can always go chat with one of your colleagues, or maybe make them aware if you think they might be the folks who should be thinking about it. So first, let's talk about the U.S. Department of Education's new agenda. They are extremely active right now, and I am focused on the department. I just want to be clear. Of course, there are always things happening up on the Hill with Congress. Right now, you've got the Build Better Back, where there's some discussion around Pell eligibility. There have been lots of machinations in the last few months around potential higher education reauthorization, although that's always a question mark, and also some standalone legislation that would impact higher ed. But I'm not focused on what's happening on the Hill with Congress. I'm very much focused on what's happening with the department. So they have announced several months ago, actually, they started announcing a sweeping and complex regulatory agenda. So independent of what may happen up on the Hill with Congress, your U.S. Department of Education is involved in rethinking and revising lots and lots of regulations right now. Candidly, I thought I regularly characterize the Trump administration's activity as sort of broad and sweeping, but I would say it's the same with this administration. And who knows, we may continue to see sort of a pendulum a shift as each new administration comes in and starts to rethink so many foundational concepts. So this is from a regulatory standpoint, this is a time of a lot of change. There is a lot under consideration, and really has been now for, I'd say eight to 10 years almost, and it doesn't seem to be letting up. so that you know, so on May 26, 2021, by the way, when you get the PDF version of these slides, the stuff that's in blue and underlined, those are links. So they should be active hyperlinks. And if you want to go look at the announcements or the underlying documents, that's why we provide them in the slides, and you can certainly do that. So on May 26, earlier this year, the department announced its intent to initiate a series of negotiated rulemakings that would cover a wide range of topics. Now, you all know your state authorization and the new professional licensure disclosures that came out of the accreditation and innovation rulemaking that occurred under the Trump administration. So this administration has announced its intent to initiate a range of negotiated rulemakings. And what that means, by the way, for those of you who may not spend all day, every day like I do thinking about these things, the Department of Ed is the only major executive agency that is required to create all of its rules that relate, in this case, to federal financial aid, through a process of negotiated rulemaking. So they have to. If it's a federal financial aid type rule, they've got to go through this process. And they literally bring a bunch of people to the table, or not literally anymore. Now it's literally on Zoom, but outside of pandemic times, they would bring people to DC, sit them around the table for 2 or 3 week sessions. And they actually hash out the rule, and the department would propose and say, well, this is what we want to do. And then the negotiators who are represent different constituencies offer their thoughts. And maybe at the end of it all, everyone agrees, and maybe they don't agree. And then the department would promulgate a rule in proposed form, and everyone out there, including you all, would have an opportunity to comment. And you'd have 60 or 90 days that would go by or more, and then they would issue a final rule. And when the department issues a final rule, if it's issued before November 1st of any year, it can become effective July 1 of the following year, right? If you miss that November 1 deadline, it's going to be pushed out an entire extra year. That's why you always see the department issuing final regulations on October 28th, October 29th, and November 1st, is because they're trying to make sure that those regulations can become effective by July 1 of the following year. It's also why most of your federal financial aid regulations always become effective on a July 1st, because that's subject to a statutory framework. On June 11th, the Biden administration released its first unified agenda of federal regulatory and deregulatory action. So if you are a policy or regulatory nerd and you're wanting to get the earliest possible jump on what an administration is thinking about, the unified agenda is probably the best place to look. All the executive agencies as part of the administration have to put together a schedule, and they say, these are all the things we want to do, either to regulate or deregulate, and this is the timetable we intend to pursue. And so it really is like a sneak preview of what's coming down the line. And the department indicated both in May and then confirmed in June that they wanted to look at 14 or more different areas for potential regulation. And they didn't expect that most of this would start until the fall, and that's right, but it is now underway. Before we get to that, I do want to take a minute, though, just to give you a look here at the board. These were the 14 issues that the department right now is thinking about. Change of ownership or control process, procedures for initial Title IV certification, standards of administrative capability, right? Ability to benefit, just skipping around, loan repayment plans, false certification discharges, all types of discharges, closed school loan, total and permanent disability, the use of arbitration and class action waivers and agreements with students, financial responsibility triggers, gainful employment, Pell Grant eligibility, 90-10 regulations. So a lot of stuff on the list. One of the reasons I wanted to throw this up, though, is because you also notably don't see state authorization or consumer information or professional licensure disclosures on the list. And I think that's something I wanted to sort of highlight for you all, which is, I don't mean to suggest that everyone is happy with the last rule that came out. I think, in fact, almost immediately after that rule hit, there were some folks, even who had been at the table, who started expressing some dissatisfaction, maybe consumer advocates who felt strongly that the way the rule worked out around state authorization, that was going to eviscerate or undermine the ability of certain states to enforce consumer protection statutes or regulations, things like that. But the rule did reach consensus, which is pretty unusual these days, right? So just to take a step back, remember I was talking about negotiated rulemaking and how it works. Sometimes everyone at the table agrees, and sometimes they don't. But to get to what's called consensus, everyone has to agree on every topic that's been discussed, right? Which is a pretty high bar. And for the accreditation and innovation rulemaking, all of those negotiators, they achieved consensus. They all ultimately agreed to that rule. So what that means is a couple of things. I mean, one is, I think the department, there are people at the department who continue to be very thoughtful about distance education and state authorization and the consumer information disclosure, sort of that whole framework, right? In fact, there are a number of people who've come in with this administration who have a real consumer protection focus, right? They used to be at the CFPB or other organizations where that was their primary role. But they have a lot of fish to fry. I mean, look at this slide. And so at some point, they have to ask themselves, the department, despite what we sometimes think about the federal government, really has limited resources. I mean, there are only so many people at the agency who can be involved in writing rules and drafting rules and going through the negotiated rulemaking process and all those things that have to be done. And they've got some really big issues that they want to try to tackle during this administration. At the same time, so I think part of it is they are satisfied enough with the state authorization and distance education, consumer information disclosures, that it's not at the top of their list. But the other thing they have to be thoughtful about is the fact that this regulation, in its current form, the distance ed and professional licensure regs, again, achieve consensus. So if they go back and rewrite them, they got to be prepared to rationalize and justify why they're almost immediately rewriting a rule where every single person at the table during NEGREG agreed on the rule. Right? And that's a problem too, because the whole idea is if everyone agrees, the department is really supposed to promulgate a regulation that reflects that agreement. And so for an administration to come along a year, 18 months, 2 years later and say, well, we don't agree anymore and we're not going to bind ourselves to that sort of concept, in and of itself can be problematic. So all of this is my way of saying, this new state authorization, professional licensure disclosure regulation, all became effective July 1, 2020, right? And there has not been a lot of rumbling, despite all that this administration is trying to tackle right now. There's not been a lot of rumbling around a serious effort to rewrite those things right away, at least. Now, you could still see sub-guidance. You could see Dear Colleagues or electronic announcements where they, sort of expand or expound on their expectations. But the idea that you would see these regulations completely rewritten, at least as of right now, it doesn't seem like there would be a lot of support for that. Just so you know, on some of these other topics, on August 10th, the department created what they call the Affordability and Student, actually, I can't quite see it here. Make sure I get it. Student loans, that's what it is. Affordability and student loans rulemaking. It's sort of like acts of Congress. They always come up with names for these things. And that NEGREG is underway. So it started about a month ago. And this week actually is the second round of negotiated rulemaking. So as we speak right now, there are negotiators who are participating. By the way, total happenstance, but you guys may find interesting. There are 3 Missouri institutions that are represented as part of this negotiated rulemaking. So the secondary negotiated rulemaker for private nonprofit institutions is from WashU. The primary for public institutions is from Mizzou. And the secondary representative for guarantee agencies and servicers is from MOHELA. So unusually, there's a lot of Missouri representation right now as part of this negotiated rulemaking. The department has already also indicated and announced its intent to start another negotiated rulemaking that specifically concerns the 90-10 rule, which was, for some of you may know, is a rule that applies only to proprietary institutions. So this is kind of what it's looking like right now. What the department did is they said, at the early part of the year, we've got these 14 or 15 issue areas we really want to tackle. And then what we're seeing is their plan is to tackle them in tranches. Right. And so this first negotiated rulemaking, affordability and student loans rulemaking, the 9 topics you see in this top sort of tranche are what are being considered. And we know now that they're going to do at least a second rulemaking specific just to 90-10. So what that suggests is if they try to tackle everything else at once, that there would be a third rulemaking, I'm calling it the TBD, where they would tackle the remaining topics that aren't being covered already. So you've got sort of 6 more that are in there and being considered. And this is right now what the negotiated rulemaking slate for the department, I would say over this, if it's a first term or only term of the Biden administration, over this term, what it's likely going to look like. Because all the affordability and student loan rules that are coming your way, if the department runs the process expeditiously, we would expect them to try to get a final rule out the door by November 1st of 2022. Which, if you recall, means that the earliest this first tranche of rules could become effective would be July 1, 2023. If the TBD rulemaking is delayed a year while they pursue this sort of highest priority grouping, That means that the TBD rules would not become effective until July 1, 2024, which of course is only 4 or 5 months before your next presidential election, right? If you want to learn more about this negotiated rulemaking, the department has a web page where they track all the neg reg. You can click on the link that's on your screen right now. It can be a little confusing the way they just throw documents up on the page, but it mostly is all there. And it includes things like the documents they're providing to the negotiators during the round of the neg reg. Proposals for negotiators will be included. And the other thing is, it's all being live streamed now. So if you actually wanted to go watch the rest of this week or the last round of the neg reg, you could. Also, if down the line state authorization, professional licensure disclosures percolate back up and become part of a new negotiated rulemaking, keep in mind that you all could actually watch that negotiated rulemaking. You could try to find out who represents your institution type and try to talk with them about your concerns. But there's a fair amount of opportunity to be engaged in this process these days with the way, the telecommunications work. It's not nearly as closed off as it was 15 or 20 years ago, where it sort of felt like it just all happened in DC. All right, and if you are interested, here is a current and projected rulemaking timeline for all the sort of neg reg activity. That's what the cool kids say, neg reg, the cool kids who wear bow ties. The rulemaking activity that we expect over the next couple of years. Let me take a deep breath. So now that's kind of what's happening in DC. And I mentioned importantly that we don't foresee, when we look in our little crystal ball, that there's going to be a lot of movement on state authorization or professional licensure disclosures. So what that means is when you're thinking about how to comply with these obligations or what the upshot of the changes from 2020 are that became effective July 1, 2020, really what you have to look at is that law. Right. And I don't think there are a lot of new things that have come out since then. The other thing that's worth noting is, interestingly enough, as significant a topic as particularly the professional licensure disclosures have been for folks who do what you do at institutions of higher education, there's been very little guidance from the department on this topic. I have not seen any sort of extensive or meaningful dear colleague letter or electronic announcement that really goes into detail about, how institutions might think about implementing these. And if you go to the FSA handbook from last year, I mean, they essentially just take the consumer information section and they've just added a couple of little, as some of you probably know well, a couple of little bullets that capture all of these changes around professional licensure disclosures. And of course, the task of implementing all of this and getting up to speed and understanding what all the different states and agencies have to say is or can be daunting, particularly if you're an institution that operates in lots of different jurisdictions. But from the standpoint of the department, as far as guidance goes, there's really not a lot out there. So what you have to look at is you've got the regulation, and then you've got the commentary to that regulation. And keep in mind, when the department promulgates or issues both a proposed and final rule in the Federal Register, there always is a significant amount of commentary that accompanies the new rule where the department will talk about, sort of what their thinking is on certain topics. And sometimes they'll get a little more into the weeds. And it is often the case that that commentary later becomes and is sort of codified in a Dear Colleague letter or an electronic, the FSA handbook or some other form of sub-regulatory guidance. Since we haven't seen that yet, what you really are going to need to do if you want to look for some of those more nuanced feelings or answers is go back to that commentary. But my word of caution, of course, is keep in mind the administration that drafted that commentary is no longer at the wheel. And I cannot promise you that this administration would take the same view on every topic that's discussed. All right, so state authorization. Again, this concept was wrapped up in the accreditation and innovation rulemaking that did reach consensus. You can see here there were several large buckets that were being considered as part of that rulemaking effort, and state authorization distance ed programs was one of them, with professional licensure disclosures at the time being sort of wrapped up into that. The state authorization rules that we're talking about today, professional licensure disclosures, again, did become effective July 1, 2020. There were another set of regulations, including those around distance education, right, and substantive and regular interaction and those types of concepts that became effective July 1, 2021. But the stuff we're talking about actually at this point is aging, you might say. It's been around for a little while. The state authorization, from my perspective, the rule accomplished two primary objectives. I mean, the first, as I'm sure all of you are aware, is that the residency problem was at least addressed. Solved may be a little aggressive, but the 2016 version of the rule was when you talked about sort of state authorization and understand, what was required. Everything was pinned on this notion of where the student resided. And that was, of course, a real problem. I know a lot of folks who do what you do at institutions. The folks out at Weechee and San and elsewhere were telling the department this is really not how any of this works. This should really all be based on where the student is located. And fortunately, one of the things that the rule that became effective last year sort of addressed was this residency problem, and it did shift the rule and focus it on the location of the student. So that's a really important concept when you're thinking about, do we need some form of state authorization? So for example, if you're beaming education and setting up clinicals and all those kinds of things in California, which is not NC SARA still, you may need to be thoughtful about where your students are located and if they're located in the state of California, right? The other thing that the rule sort of got to was reciprocity. I know not everybody is satisfied on this point, but in particular, the degree to which participating in SARA obviates the need of an institution to comply with the state authorization framework in other states versus general purpose laws or laws outside the state authorization framework in those other states. And my guess is most of you are hip to this distinction at this point because of what you do at your institutions, but this still causes confusion, and we get calls about this all the time. Just to be very clear, right, and I'm sure this may have been talked about earlier. I mean, the NC SARA team has been preaching this for years and years, but just to be very clear, right, when you participate in NC SARA, the reciprocity that you're receiving, what you no longer have to comply with, generally speaking, are the state authorization requirements in all of those other states. But those other states may well have many laws, and most certainly do, that are outside of that state authorization framework, like general purpose consumer protection laws, right? Or consumer finance laws, or any kind of law that isn't part of the educational state authorization framework. And if you're interacting with their citizens and you run afoul of one of those laws, you could be subject to some sort of action. Of course, professional licensure requirements, the requirements of specialized boards of education, nursing boards, don't fall within that state authorization framework typically. And as a consequence, you all still have to comply with those various obligations, despite the fact that you are participating in NC SARA. And again, I'm sure many of you know this, but it can be complicated. Where the rubber can really hit the road is where on limited occasions you see states that have created rules that may or may not be inside that state authorization framework. And there can be some question, if the Attorney General has created some rules that weren't promulgated and aren't overseen and enforced by the state entity that authorizes institutions of higher education. They're managed by the Attorney General, and they're really consumer protection type rules, but they are specific to institutions of higher ed. It sort of does raise this question of, well, wait a minute. I mean, is this sort of a workaround reciprocity? I understand that, this is a Attorney General rule and it's not enforced by the state authorizing agency. On the other hand, this looks a lot like the kinds of rules that typically are enforced by that state authorizing agency. And that can become a sticky wicket. I know NC SARA has been involved in some of those conversations, and occasionally our law firm is involved in those kinds of conversations as well. But the real salient point here is just to keep in mind, I don't think the department left much doubt as far as their position on this, even though I've heard people express some feeling that maybe they were vague. I really don't think they were. I think the department and the commentary and the rule were pretty clear that their notion is that the state reciprocity covers the state authorization framework, and that states are fully able to and will, and is their expectation, enforce their, as they call it, sort of general purpose state laws, those things that are outside of the state authorization framework. So I don't think there's much question on that point. Also, I think just, it is my opinion from a sort of legal standpoint that that's the appropriate idea here. I mean, when your state signed on to NC SARA, they weren't signing on to anything that would suggest they couldn't enforce their general purpose state laws, right? Let me, you know what, let's hold questions to the end, but I do want to get through this, and I definitely want to get to questions. And if you have questions specific to like state authorization or the stuff at the top, I'm very happy to talk about all those. But let me go ahead and try to clip through the licensure disclosures. Again, I say the newish disclosures for licensure programs. And I suspect you all have seen this quite a bit, but maybe we can offer a little extra mustard here, as they say. So as you probably know, the requirements around disclosures for distance education programs, including distance ed programs leading to professional licensure, were originally in this 66850. And 66850 was a section of the regulations that was created specifically to manage distance education programs. So the disclosure requirements and all these other obligations around distance ed programs were in this new section that had been created. The prior administration, the Trump administration, when they sort of approached all of this, they said, you know, we think there's merit to some of these disclosures, and we think there is not merit to others. So the ones they didn't like, they just jettisoned completely. But the components that dealt with professional licensure, they said, you know, not only do we think this is valuable, but we really can't understand why we would only make these disclosures with regard to online programming. I mean, shouldn't a student in a brick and mortar program know whether or not when they graduate, they'll be able to become a nurse or become a teacher or do whatever in the jurisdiction in which they're located? And I think initially the thinking was, well, the only place this would really become an issue is in online programming, because, you know, when you talk about a brick and mortar campus, students are going to know, and that brick and mortar campus presumably would have created the program with that state's requirements in mind. But the example I always use is, you know, what if you're in Memphis, right? I mean, you may have students from Arkansas, from Missouri, from Illinois, as well as from Tennessee, all coming to your physical campus. And, you know, you probably should have some sort of disclosure, even for your brick and mortar professional licensure program, to make sure that the students coming from those geographies, right, which are likely, understand whether or not when they graduate from the program, they'll be able to go back home to, again, Arkansas, Missouri, Illinois, Mississippi, or Tennessee and do whatever it is they've signed on to do. So particularly if you're in a place that's near a lot of different states and jurisdictions, even for brick and mortar programs, you can see why that would become really important. So, so that's what the prior administration did. And they took these professional licensure disclosure requirements and lifted them up out of 66850, which had been designed, again, just for online. And then they put them over into 668 43, which is 41, 42, 43, which is where the traditional consumer information disclosure requirements of the department are all located. And that's all your financial aid information. That's your institutional information. That's your Clery Act disclosures. That's FERPA disclosure. All of those sort of fundamental consumer information disclosure requirements tend to be addressed in 41 and 42 and 43. So focusing on the licensure question, the department said, look, if you've got a covered licensure program, you need to make these disclosures for your students. And then they try to give you a little bit of meat on the bones as to what a covered program would be. So they said, we're talking about a program that's designed to meet educational requirements for a specific professional license or certification that is required for employment in an occupation, or that the institution is advertising as meeting such requirements. You know, I get questions all the time, and folks will say, well, what if we've got a program and when folks graduate, they can optionally, they have the opportunity if they want to go seek some sort of national certification. It's not required for employment. You know, we're not making representations that our program is preparing them to get that, but we know many of our students elect to get it because it's attractive and it will increase the likelihood that they'll be employed. Great, and it's great that your program prepares them to do that, and hopefully they'll all obtain that certification. But in that case, it is unlikely that your program is a covered program, right? Because one, you're not advertising that the program is designed for them to get that national certification. And also, more importantly, that certification isn't required by any state or jurisdiction or practically by employers to be employed after graduation, right? So it is thoughtful to always, as a first step, sort of evaluate your programs and think what's a covered program and really what's not. And in some cases, you might think one is covered when really, after you're thoughtful about it, you determine it's not. It can also work the other way. I was shocked a few years ago, actually, this is probably a decade ago. I don't even know if it's still the case. But at one point, to hold yourself out as an interior designer in Texas, there was an agency that certified you, and you had to become certified as an interior designer. And I was working with a school that did not even know that. And they had a program that was not designed to satisfy the educational requirements so that when someone graduated, they could get the in-state required certification to be an interior designer. And it created a real problem for the school, of course, and also for the students and the graduates. We got it all straightened out, but they had no idea that that was a professional licensure program, actually, which was interesting because you would think it's the kind of thing you might know. So it's always a worthy first step exercise to really ask yourself, is this a covered program? And on a go forward basis, as you guys are talking with your academic folks and you're designing programs, I would make that part of the whatever the sort of algorithm is for designing curriculum, creating new programs, and rolling them out. And that should include academic considerations, financial aid considerations. And one of the other things that should be sort of a box that gets checked along the way is whether or not it's a professional licensure program. So you can make sure you're satisfying these requirements, or decide whether you want to be burdened with the obligation of satisfying these requirements, if this is really a space you want to step into. So if you do have a program that's covered, once you've made that determination, you've got that universe of covered programs, you have to do a couple of things. You have to make certain what I'll call make available disclosures, and then you have to make certain what I'll call direct disclosures. And this has been a dichotomy the department has honored for many years. Make available disclosures are things that have to be in appropriate print advertising on your website, etc. But you're not handing them directly to a student, right? Direct disclosures, on the other hand, are disclosures that you do have to hand directly to a student. So the department's got a lot of stuff in the make available bucket, and they have a lot of stuff in the direct disclosure bucket. So when we're talking about disclosures for professional licensing programs, you've got both. On the first piece of that, you've got this make available disclosure, and the department's expectation is you're going to make available information regarding whether completion of that program would be sufficient to meet licensure requirements in a state for that occupation, including, and then we've got the lists, right? And this is what the department really focuses on, is these 3 required licensure lists. So for each covered program, first of all, on your website, appropriate materials, you're supposed to have your positive licensure determinations list. So you're just saying for this program, this is a list of the states for which we as an institution have determined that our curriculum, our program meets the state educational requirements for licensure certification. By the way, the phrasing here I think is good, and I would encourage you to use for a couple of reasons. One is you're parroting the regulations, so there's a little question that you're saying the right thing. But this is also a good and important way to say it, because it really is what you're representing to a student is that you are meeting the state educational requirements for licensure certification, not that you're providing them with all components that may be required for licensure certification. Because as many of you know, sometimes in addition to having the education, you have to have some sort of shadowing experience. You may have to have some sort of post-graduation clinical or internship experience. You may have to pass an exam, right? I mean, there are a lot of other things you might have to do before you can actually get the license. And you as an institution just want to be clear that what we're representing is we're providing you with the state educational requirements for licensure certification. Okay, so that's your first list, and that's just a list of states. And then you have your negative licensure determinations list, and that's a list of states for which you have, as an institution, concluded, determined in a meaningful way that your curriculum does not meet the state educational requirements. And then finally, you've got your no licensure determinations list, and that's a list of all states for which the institution has not made a determination. Okay, so the question we got as soon as this came out, everybody was really thoughtful about, and this was addressed quite expressly in the commentary, was, well, wait a minute, do we have to go make a determination for every state? And I think in 2016 and under prior versions of the state authorization rules, for example, there was a feeling that institutions were compelled to go out and make determinations in every single jurisdiction, right? And that's not what this rule was really designed to require. And the department spoke to that specifically. And I've got a couple of choice quotes here from you from the commentary that accompanied the rule. They said the regulations do not require an institution to make an independent determination about whether the program it offers meets the licensure certification requirements, right? The regulations provide that an institution may disclose that it has not made a determination as to whether a program's curriculum meets the state's educational requirements for licensure certification, including that option provides sufficient flexibility so that an institution need not incur any additional burden. Well, there is some additional burden, but the idea is you do not have to go out, particularly if you think in the context of like a brick and mortar program, right? Okay, so you're in Memphis, you're offering your nursing program in Memphis. It's not online, it's only on the ground, okay? Do you really need to go out and make an affirmative determination that your graduates are not going to be able to be nurses in Oregon or Alaska or Florida, particularly if you don't have a single student from any of those states. And that's not what the rule is requiring. This is an important point. But what that means is then you've got some decisions to make about where you're going to go out and try to make an affirmative determination and where you may take a pass. And then the other question we get is, am I really supposed to cover every state in one of these three buckets, right? So the first thing the department says about this, they say, I'm focused on the second bullet here. If an institution opts to confirm, not to confirm, pardon, if an institution opts to not confirm whether a program meets the requirements for a state, because it enrolls a small percentage of students in that state, or maybe none, the institution will remain compliant by disclosing that it has not made a determination. But, cautionary note from the department, while we don't preclude the institution from advertising a program for which it's not made a determination regarding the program's alignment with state licensure or certification requirements, the department expects that schools will accurately and truthfully provide that information on the required disclosure. What the department's getting at here is, look, if you're going to advertise your on-ground nursing program in Alaska, then you need to make a disclosure, right? You need to be real clear up there, and it needs to be very clear to students if they come down that you've not made a determination, right? In other words, it could be negative. It might not be the case that they could go back to Alaska. I mean, my advice would be, if you plan to be in a jurisdiction other than your home state, whether that's through online or on ground in a meaningful way, then you probably should give some real thought to making an affirmative or a determination one way or another, but finding out conclusively where you think you fall. But if you're on ground in that nursing program and for the last 50 years you've never had a student outside of 4 or 5 states, then I think you're pretty comfortable. Just put all the other states over in your no determination list, because you don't have students who are coming in and going back to those states, right? If you're online, you want to be thoughtful about where you're advertising and where your students are coming from, right? When making this decision as to where you want to have a determination or not a determination. Also, we're going to get into some direct disclosures in a minute. And if you're just going no determination for a huge chunk of states, it can also create some complications with regard to your direct disclosure obligations. But here's what I usually suggest, and that is, for each program that's a professional licensure program, I think you need these 3 lists, and I think every state ought to be accounted for, right? And that may seem a little exhaustive, and I know marketing may hate the idea that for that on-ground nursing program, you've got a no determinations list that's got 40 states in it. But you really need to have every state accounted for. Either you've made a call and it's yes or no, or you're unclear. The other thing is, and we're going to get into the direct disclosure obligations in a minute, but in order to make those direct disclosures in a timely and appropriate way, you've got to know, and the institution's got to have a record for each of your covered programs, whether it's a yes, no, or no determination. Right? I mean, you've got to know that, and whoever is responsible for monitoring and potentially, making these direct disclosures is going to have to be thoughtful about that and have access to that information. All right, so direct disclosures, what do I mean? So prior to enrollment, you have to directly notify a prospective student if the institution has made a determination that the program does not meet state licensure requirements in the state in which the prospective student is located, or if the institution has not made a determination regarding whether the program meets state licensure requirements in the state in which the prospective student is located. So, one of the things you're going to have to do is have a mechanism in place, obviously, first of all, to know where folks are located pre-enrollment. And I'm going to talk a minute what I mean by that when I say enrollment, because I understand not all of you have enrollment agreements. But prior to the point at which you consider them enrolled, you've got to make a decision as to whether or not there is a direct disclosure obligation on your part. And so that means you've got to have a mechanism in place to know, someone's got to be reconciling where they're located against your program and where you've made positive, negative, and no determinations. You also have an obligation within 14 calendar days to directly notify a current student if the institution has made a determination that the program's curriculum does not meet the state educational requirements for licensure or certification in the state in which the student is located, right? So again, you have to have some process for knowing where students are located, and if something has caused you to go out and make a determination, and now you have an understanding that something that was previously either approved or no determination, you now have knowledge that it is a no, then you need to reach out and let those students know. And of course, you need to update your external website and your make available disclosures to move that state into the correct bucket. Direct disclosures must be made directly to the student in writing which may include through email or other electronic communications. My advice would be you also need to have some mechanism in place to show, to record that that direct disclosure was made. I don't think you need to have something showing that the student received it necessarily, though that would be nice. But keep in mind, and I tell folks this all the time, it is one thing to comply with the law. It is another thing during a program review to be able to demonstrate that you are complying with the law. And I have had situations where clients have made disclosures and announcements, and then a year later they've got a program review, and we say, the department says, okay, we need evidence that you provide that annual notification to everybody about your annual security report, or we need evidence that you were making these direct disclosures. And the school says, well, we send the emails out, but we don't have any way of pulling from our system or showing you that we're doing that. And the department says, well, then we can't verify that you're actually complying with the law. So not only do you need to have the mechanisms in place to do what needs to be done, but just always keep in mind, you also need to be able to demonstrate down the line that you have been doing certain things. So you want to have some way of showing the department that these direct disclosures are being made. Couple of additional thoughts: determining and documenting a student's location. This is one that comes up. So an institution has some flexibility here. You obviously have to make a determination regarding where the student's located. The department says you got to do it at the time of the student's initial enrollment, and if applicable, upon formal notification that the location has changed to another state. So you need to have some way of knowing if students are moving, right? Determinations regarding a student's location must be made in accordance with written policies, which must be applied consistently. So the department is not telling you how to do it specifically, but what they're saying is you have to have a policy in writing that articulates how you do it. You have to do it consistently. And again, if we come knocking on your door, you need to be able to show us that written policy and show us that you're executing on it in a consistent way. In fact, the law specifies upon request, institutions must be able to provide the department with written documentation of its determinations regarding a student's location, right? As including the basis for the determination. So remember, this isn't just a requirement to make disclosures either, whether that's externally and make them available or direct disclosures. It's also a requirement to document how you are doing that and that you are doing it, right, to achieve full compliance. Timing of direct disclosures: the department expects that the institution will provide the disclosure before a student signs an enrollment agreement, if you got it. But for many of you who don't use enrollment agreements, before the student makes a financial commitment to the institution. And that's typically for traditional higher ed where the department has drawn that line. As an aside, I hope to do a presentation in the coming weeks or months about enrollment agreements in traditional higher ed. I think we finally may be getting to a point where it really makes sense for traditional institutions to think about having one. The problem right now is, for a very long time, courts were pretty comfortable saying there was no contract between students and institutions, or at least if they were going to imply one, drawing it very narrowly. The problem is courts are now getting much more comfortable saying, well, we think the catalog's contract, could be a bulletin, could be anything you provided in writing. And the Department of Ed, when they did the bar defense rulemaking in 2016, actually said, because a breach of contract is a basis for a bar defense claim, they actually included, they said in the Federal Register commentary, well, we think a contract is anything in writing. I mean, again, catalog, any kind of student handbook, bulletins, all of the syllabus, all of these things. The department said, well, we would construe all of that as a contract. So the problem is, for a long time for institutions, it was kind of to their advantage not to define the contract, right? But now, if they don't do it, what's happening is regulators are going to do it and courts are going to do it. And some institutions are involved in class actions right now over moving online during the pandemic. And that's what those courts are considering, is what is the contract? So if I'm an institution, including a traditional institution these days, it might be worth starting to consider whether or not we should have some sort of agreement in place between us and the student that says, this is the scope of the agreement between the parties and what we're obligated to do, and also what we're able to do, like in the event of a pandemic, move you online. Because right now, for a lot of schools, there was nothing like that in writing. So just an aside, but keep in mind, I think there may be a shift in that arena as well. Finally, I'm just going to hit very briefly on these more newish disclosures. They're in the slide deck. You can come back and look at them. I want to get on to questions. But the thing I wanted to highlight, I mentioned earlier that the professional licensure disclosures were moved into the traditional consumer information section of the regs, which is 668, 41, 42, and 43. What's interesting is, and was overlooked, I think, by many, the department during this rulemaking also changed some of the other consumer information requirements, and they revised some things and they expanded some other things, right? So you see here, this is everything on here that you see is something that's required to be provided, consumer information that has to either be provided directly or made available, right? And the things that are outlined in yellow were the things that changed during this last rulemaking. They were either formalized or revised or expanded in some minor way. They weren't typically huge changes, but there were changes. And what's interesting is if you look all the way at the bottom on the right, direct disclosures for licensure determinations is only one of these boxes. So there were lots of other changes that took place. And I'm not sure that, at most institutions, there typically is not a single person who thinks about all of this. A lot of these different things fall into different buckets and verticals within your operations, right? But I just wanted to highlight for you, and maybe you can go talk with compliance or legal or whoever and say, hey, just by the way, have we checked on some of these other things? Just to give you a quick overview. So for example, credit transfer and written arrangements. The department rides a little bit the way that these had to be approached. And looking, for example, at the second bullet, institutions now have to include information concerning their written arrangements with other institutions in the description of the impacted program. So what I mean is, let's say you've got a criminal justice program and you've got a written arrangement with another institution or non-institution, maybe a local police department or someone like that to provide some portion of the program. The department's saying that that arrangement, at least fundamentally, is supposed to be disclosed in your catalog and the other places where you talk about the program, right? Enrollment demographics. So the new rule specifies that institutions have to make available, publish out there somewhere, the percentage of students enrolled, full-time students at the institution who are male, female, federal Pell Grant recipients, or self-identified member of racial or ethnic groups. Some of you get at some of these kinds of concepts when you do your IPEDS reporting. Some of this is available at College Navigator, but the department is saying, look, you as an institution have an obligation to make some of this disaggregated data available on your own websites and in your information. Outcomes, if you are reporting, calculating, and reporting some sort of placement rate, there's an expectation codified that you're going to be making that available. And also retention rates and some other concepts have been tweaked a little bit. And then fire report, vaccinations, and teach out. Now, a lot of this you may have already been doing, but the rule was revised to make very clear that your fire safety report, for those of you who have residential components on campus, has to be made available. And a lot of you wrap that into your annual security report, and that's probably already out there, but it wasn't previously expressly required. Institutional policies regarding vaccinations. And it's interesting because this came out, remember, this rule was promulgated in 2019 before the COVID pandemic. And finally, if you are required to maintain a teach out plan by your accrediting agency. Now, some of you may be thinking, well, that would never apply to us. We're a huge institution, but keep in mind, you may be required to supply a teach out plan if you close a location. So if you're a campus out there, an institution that has locations all around the country or the world, all those additional locations that are sitting on your e-car and approved as branches by your accreditor, you may be obligated, if you go to close one of those locations, to supply a teach out plan. And you've got a disclosure requirement related to that, right? So little things, agency enforcement actions. Also, there's some disclosure required around that. You can look at this in the slide deck. And then finally, my pitch, because I see schools miss this all the time. Foundationally, one of the oldest requirements in the regulations is that every year institutions circulate a notice to all students telling them with some specificity where all this consumer information is located. And it's interesting because I have a lot of schools I've seen over the years that are making a lot of this consumer information available on their website. We got our FERPA disclosure here. We've got our Title IX stuff, our annual security report. It's all out there. But they're not circulating every year a notice to students that tells them where all this stuff is located and provides the URLs. And that's actually a freestanding requirement in the regulations. So if you didn't know that, I encourage you to connect with compliance or your legal counsel, or whoever might be responsible or capable of putting that kind of thing together for you. Just a last note before we get to questions, so that you know, we put a lot of information out on the wire that's totally free. We have our blog. It's supposed to be Regucation, but everyone says Regucation. And one of these days, I'm just going to give up the ghost on that. We have webinars we do that are also free and then available after the fact on demand. If you're a lawyer, most of them are also certified for continuing legal education in the state of Missouri. I'll note here, we've got one coming up on November 10th, best practices and considerations relating to summer camps on campus. We have training series we do. We did a big Title IX one last year. And then we've got other compliance materials. You can find all of this stuff on our website. You're welcome to sign up for the blog. We'd love for you to check in on the webinars. Again, all of those are just free materials that we make available. And then here's my disclaimer at the end that says I'm not your lawyer. All right, I will take this off sharing, and I'm delighted to field questions if we have time.
Awesome, Aaron. And we did get some questions in chat, and then as usual, I have questions as well. Let's get to chat first. For professional licensure disclosures, do we need to include the District of Columbia and U.S. territories, or is it just the 50 states?
You know, that's interesting. I'd have to go back and look at the definition of state. I actually think the definition of state does, I'm pretty confident it covers for sure the District of Columbia, in just meaning in the regs. But, you know, my advice would be as a practical matter to definitely do the District of Columbia. You know, I don't know if you need to do the Marshall Islands and, you know, those types of things. If you've, but let me say too, I take a very practical approach to all of this, right? I mean, I know I said you should try to account for every state in your disclosures. So again, I would definitely do District of Columbia. If you've never had a student from Puerto Rico, okay, maybe that's not a big deal. But if you get a lot of students from Puerto Rico, I mean, if you're located in Miami, right, and you're pulling a lot of students from that part of the world, then yeah, I would include them. I mean, I just think it's smart. One of the things that I always encourage my clients to do when they reach out to us about anything dealing with state authorization or disclosures, et cetera, is I say, produce for me for the programs at issue. And if it's just one, just one. But, you know, I want to see a list of every state and how many students you have in that state. Because I'm a risk manager. That's what attorneys do, right? And if I've got one student in a state, I'm not as concerned about it. But if you've got a significant percentage of your enrollment, whatever that number might be, you know, but if you've got a lot of folks there, then yeah, you want to be thoughtful about it. So District of Columbia, yes. Puerto Rico, maybe no. It doesn't keep me up at night unless you're recruiting there and you're pulling students from that location, in which case I would definitely include it. Great question.
And let's see, what are your thoughts on the USDE's updated definition of distance education, where one course offered via distant ed makes the entire program distance ed?
Well, that's interesting. I don't exactly take that view of the definition. So, and this is, I don't want to, maybe this is a little lawyerly, but the way I read the department's definition is you have to satisfy the requirements of distance education if any part of a program or course are distance education. So it's not that they're saying that this one course that's offered by distance education somehow turns the entire program into, I mean, the point is that course is distance education. And so you have to comply with the definitions and the required elements of what is distance education. And if you're not, then it's not distance ed. So it must be telecommunications. I think that got thrown out, right? Correspondence. But you know, I don't really think of it in terms of, and I understand the question, you know, I don't think of it in terms of, well, we've got a single course and so that has turned the whole program into a distance ed program. I think what the department, the concept really here is, look, you know, we're trying to ensure quality. And if any component is being offered through this modality, then you have to satisfy the quality assurance measures for that modality, right? And those quality assurance measures happen to be built into that definition of distance education. So if it's a distance ed course, then that course has to satisfy those requirements. The other courses, if they're on ground, those courses aren't distance education, right? So there's not an expectation that they're going to satisfy the definition of distance education. But for that course, there is. And I think that's necessary because, well, I shouldn't really take a position, but I understand why folks would think that's necessary, because if you're offering 40% of the courses in a program via distance education, and the department was taking the view that the rules either going to apply or not apply on a program level basis, then 40% of your program might not satisfy those requirements relating to substantive and regular interaction and all these crucial concepts around distance ed that are really necessary. So I don't know that the department had much option other than to take this down onto a course by course level, candidly. You know, I think the interesting question is, what if I've got a single course? that is meeting 60% of the time online and 40% of the time on ground, because now we're even talking like within a course, like what component of it has to satisfy those requirements. My view is anytime it's online, it ought to satisfy the quality assurance concepts that are built into that definition of distance education.
Somebody had just mentioned the term in part or in whole is making us question the concept. So, if you want to hire Aaron, I'm certain you
yeah, that's right.
Otherwise,
absolutely. That's right.
maybe,
I do this for a living, by the way. I should have mentioned that. So, always happy to have.
We don't want him to get in trouble in offering legal advice, that kind of thing.
No, right. But look, it's a fair question. Don't get me wrong. It's a fair question. I think accreditors and the department and others are still wrestling with it. It's been around for a long time, but my guess is most folks, certainly if you're my age, this whole distance ed concept as we currently conceive it is still very new, right? It's still very new. So, and the law and the regulation is always behind all of these concepts and trying to figure out how to manage them. So, this may not be the last word by any stretch.
I had a question then, and it dealt with that kind of third pocket of potential rulemakings that they may do, and it had to do with the ability to benefit. Are they talking about bringing that back? I hadn't heard about that.
Yeah, and there's some availability right now for ability to benefit for a very narrow type of program. For certain programs, if they qualify in a certain way, even now institutions can do some ability to benefit analysis. I think my understanding actually is that most of what's being thought about here for a long time, you guys will find this interesting, Laura, you in particular, for a long time, there's been one of the ways that you could qualify somebody for an ability to benefit sort of embedded in the law was if they took and passed some sort of state assessment. And it was rarely used, in part because nobody really knew what that meant. A lot of states didn't really have anything. Or no one had sort of stepped up and said, well, this is our version of this that should satisfy the law. And I think part of what this rulemaking, the focus of the rulemaking is actually to figure out what that means, right? So we've talked about a third-party exam. We've talked about if someone demonstrates they can pass a certain number of courses. But there's always been this sort of third prong hanging out there about if they've taken some sort of state exam or assessment and been certified as having the ability to benefit. And I really think the focus here is to try to figure out what that means, or if it should even still be there.
Okay, thank you.
But yeah, that's still out there though. I don't think that's really been run to ground yet.
Yeah, okay. It might be things to think about in the future. Jeannie Aggie-Fine said this term state does include DC per 600.2 Code of Federal Regulations.
Thank you, Jeannie. Yeah.
Another comment with regard to enrollment agreements. We have students able to sign an enrollment agreement on their own anytime after they have expressed interest in the program. We are 100% online. So in your view, would we need to make the state professional licensure direct disclosure to prospective students prior to that?
Yes, 100%. So just to be clear, and sometimes there's a disconnect when you talk about this concept of enrollment for institutions that have an enrollment agreement, because if you don't, it's even more vague, right? When is the student sort of enrolled? At what point do they have a financial obligation, right? But if you have an enrollment agreement, even there can sometimes be a disconnect between sort of the legal thinking about what it means to be enrolled and the operational thinking, because folks in admissions or academics may have a different idea. They may say, well, when we've sent out the application and they've accepted our offer for admission, that's the point at which they're enrolled. Or when they come and they register for classes, or despite the fact that there's actually an enrollment agreement that they're signing, they still think of it as happening at a different point. I've even had folks say, well, we have a student management system. And a student is enrolled at the point at which they are switched in our system from prospective or whatever to, current student ready to start. And that, I will tell you as a lawyer, my view is very simple. They are enrolled when they sign the contract. Because if you have an enrollment agreement, the purpose of that enrollment agreement is to serve as a legal contract between the institution and the student and to articulate the point at which the legal relationship has been formed. You now have an obligation to the student has an obligation to you, the terms of those obligations, etc. And so when they sign that enrollment agreement, that legal document, they are enrolled at the institution and they are taking on certain obligations, as are you. If you've got any kind of disclosure, whether it be your accreditor or a state or an AG or the U.S. Department of Education, that is supposed to be made to a prospective student, meaning prior to enrollment, then my view is it must be made before they sign on the dotted line, right? Because once they sign that legal contract, they're enrolled. And if you had an obligation to make a pre-enrollment disclosure, you've missed your opportunity. So yes, my view is quite strong that if you've got an enrollment agreement, any required disclosures that they're supposed to be made pre-enrollment to prospective students should be made before they sign that agreement.
And
Okay,
Evan
thanks.
followed. I'm sorry, Evan, is that you?
Yeah, that was me. I was just saying thanks.
You bet. You bet.
Yeah. I had a follow comment there. Yeah.
Yeah. Did you want to follow up on that?
Yeah, I was just saying that we have some students that they sign the enrollment agreement, but they don't start in any classes. So that's just where it makes it hard for us, just due to we don't have as much steps because we're open admissions school.
Yeah.
So we don't have that kind of like offering in the application, and then we have to accept it as a school. It's more self-serve.
Yep.
So it just means we have to push that direct disclosure up further in our process.
Absolutely. Yeah, I would have some, I mean, I work with online institutions, sometimes that will use like DocuSign or something like that, and you'll literally put it into the system so that the student has to view it's like, I don't know if anybody we refinanced our house this year. And, they push to you all these documents and you have to go through them in a certain order and indicate that you have viewed them before you can get to the end. And that's actually a nice system for institutions that are online or using digital platforms if you've got pre-enrollment disclosures, because it requires the student to go through those disclosures and at least click through them and indicate that they've reviewed them before they sign the enrollment agreement. And of course, the great thing there is now you've got that record. I mean, you don't have to create some independent system for tracking or document. It's built into DocuSign and it produces a record. And this is why the banks and others use it, so that if somebody asks you down the line, a regulator, banks like institutions, regulated, if the regulator asks, you say, yes, we have the system. It's a closed system. We can show you that they had to go through all these disclosures, et cetera. The other thing I love about those systems, by the way, as an attorney type, is I can create documents that have been signed off by legal and compliance and whoever, and we put them into the system and nobody can monkey with them. So I don't have to worry about anyone altering those documents or getting the wrong version. It's a controlled environment. And from a compliance perspective, it's great. I appreciate not everybody can do that, but I'm a big fan of even if a student is physically on campus in a room with an admissions, officer, I still like the idea of them going to a digital platform and having to go through those documents in order and indicate that they've seen each one, all those kinds of things in a closed system. Well, it's great from a control perspective.
Sorry, I don't want to take up too much of your time just on this because there was another question, but that does raise the question in my mind. Can the verbiage about the direct disclosure just be included as part of the enrollment agreement document itself, or does it have to be in a separate document that they would have to see?
Yeah, I don't think it has to be, but typically if you're designing an enrollment agreement, you're going to want to design a contract that can be used by lots of people and lots of different programs at your institution. And this may be a disclosure that's only required for, 5% of your students who are enrolling in that program. And also the disclosure is going to change depending on, whether you've got an affirmative or a negative or no determination. So the problem I would have is if I were designing this for you guys, I'm creating an enrollment agreement that I want every student to be able to sign. And, I don't know, are you asking me, I'm just saying hypothetically, if a school's saying to me, I just have to say, well, do you want me to create lots of different versions of your enrollment agreement? It seems to me what we should do is create the fundamental contract, and then we have freestanding disclosures that are used depending on what the student requires. And then we can feed those into the system. And if it is in a closed environment, depending on how they answer certain questions, where I'm located, it will automatically populate that required disclosure in, and they'll have to go through it before they can get to the enrollment agreement. The other thing I highly recommend to everyone, I have a thing I call a pre-enrollment checklist. I think every institution should have one, whether you are traditional or non-traditional, whether you use an enrollment agreement or not. It is a document that the student goes through with their admissions officer, and it says, yes, I've been provided all of these things. You know, yes, I got the tour of the campus. Yes, I got to meet with the financial aid. I mean, you decide what you want as an institution, but both the student, prospective student, and the admissions officer sign it. And now the institution has a record that shows that the institution confirmed and their admissions officer confirmed that they had talked through and hit all these particular items in advance of taking on any financial obligation or otherwise enrolling or registering at the institution. And I will tell you again, I'm a risk adverse attorney type, right? But I love that idea because I've been in plenty of situations with regulators, AGs, and in court where a consumer student or a former student said, well, they never told me that. And the school says, well, we tell everybody that. That's part of our process. Well, you didn't tell me. I never heard that before. You know, or well, I understand, you know, that you're telling me X is true, but that's not what they told me. And having a pre-enrollment checklist, it's not a fail-safe. They can still make that argument. But if you're dealing with a regulator or you're dealing with a jury, which every once in a while we've had to deal with, you know, if you can show them a document where you say, look, the student, I mean, they went through and they checked a box, every one of these, saying that they received or did these things, and the admissions officer did the same thing, and it changes the nature of the conversation. So I think it's very important control, again, to have in your enrollment process, if you can.
Yeah.
So,
Well, thank you.
I have one more question in chat, and I have my own state regulatory thoughts about it. Should every state be specifically listed, or is it appropriate to state that we have not made a determination that the program will meet licensure requirements in any state other than Missouri? So, Aaron, you want to take a first stab at that?
Well, I mean, first of all, if I were going to say it, I would say, you know, any state that doesn't appear in on our affirmative determination list, you know, or our negative determination list. I mean, I would be real clear because remember, you're supposed to have 3 buckets. So at least as a minimum, I would say, here are our positive determinations for educational requirements being satisfied. Here are negative determinations. And then my disclosure would be, you know, very clear, bold print for any state that doesn't appear on one of these 2 lists. We have not made a determination, and that includes all 50 states and the District of Columbia or something like that. I mean, that might get you there. Don't get me wrong. If you could just list all the other states, that's probably better. You know, and safer. I don't think the department, at least, I don't think the regulation and their guidance would preclude you from using the former sort of approach. But again, it's always easier if you just list it, and then if there's ever a question, you can just say, look, it's right there. There's the state, no determination, right? It puts more burden on the student or the consumer to have to go look through those other 2 lists and do like a process of elimination to figure out where their state is. I don't think it's a huge burden, but it is an additional burden. And again, depends on your risk tolerance, but if you're trying to be safer, then I would just list the states.
Thank you. And I had put links in the chat, both to Missouri's professional licensing boards, as well as the page on NC SARA's website, where they have done a lot of the water hauling for us. And for certain professions, they've put, like, for each state, here's this contact information. We would not consider you just saying, here's the Missouri boards and here's NC SARA's, go look. We would not consider that to be meeting those professional disclosures. So don't just link. You do have to do some work, as Aaron was pointing out. Well, Aaron, wonderful presentation as always. If anybody has not had a chance to sit in and listen to his higher ed webinar series, you really should. They're super informative. He breaks it down so non-lawyers like me can understand. And lawyers get credit for it if you are an attorney. So any last comments, Aaron, before we say goodbye?
No, I'll say 2 things. One is, thank you so much for having me again. It's a pleasure. Thank you for everything you all do. I mean, I did not stumble into higher ed. My whole career is in support of higher ed because I believe in what our organizations do. So thank you for that. And the other thing is, I'll encourage you to stay engaged with the negotiated rulemaking and all these rules that are coming. It is possible to do it now from home, from your computer, in a way that we never could before. And it is a great opportunity, and it's an important thing for you all who are at institutions on the ground to do, because hard as it may be to believe, the folks in DC don't always know exactly what it's like to be at an institution day in and day out. So I think your perspectives are very valuable ones. I'll just put it that way. Have a great rest of your day, and thanks again for inviting me.
Thanks, Aaron. Thanks so much. So if anybody had any other questions for Aaron or for Emily, Jeannie, or Marianne, you can still put those in the chat, and Alicia and I will capture those throughout the day, and we'll make sure we get those to them. And then in our follow-up emails to everybody, we can say, hey, this is what so-and-so said. Or of course, you can always contact them directly. So we're a little bit behind, but that's okay. We had a big earlier break. We are going to take a lunch break right now, and we will be back at 12:30 to talk with SARA. We talk over SARA application, complaints, and fees, and that will be presented by myself, Alicia, and new guy, Steve. Have a great lunch. We'll see you back at 12:30. Bye.